Professor Dicey, the professor of English law, wrote in his book, An Introduction to a Study of the Law of the Constitution, and I quote, "We mean in the second place, when we speak of the rule of law, as a characteristic of our country, not only that with us no man is above the law, but that here every man, whatever be his rank or condition, is subject to the same law of the realm and amenable tradition of the ordinary tribunals," end of quote. This is also classically captured by Thomas Fuller when he says that be you never so high that the law is above you. In this vein, the distinguished author Tom Bingham wrote at page 4 of his classic The Rule of Law in these terms, and I quote, "So if you maltreat a penguin in the London Zoo, you do not escape prosecution because you are an Archbishop of Canterbury. If you sell annex for a cash reward, it does not help that you are Prime Minister. But the second point is important too. There is no special law or court which deals with archbishops and prime ministers. The same law administered in the same court applies to them as to everyone else," end of quote. May God help us to continue to build a society founded in the rule of law and respect for fundamental human rights. I'm profoundly grateful for the opportunity. God bless us all.
Thank you very much. The Honorable Attorney General and Minister for Justice, Honorable Godfred Yeboah Dame. Baffour excelled in his career as an Asante diplomat, a valuable repository of Asante and Ghanaian social, cultural, and political history, a defender of the power of traditional leadership in the face of the onslaught on modern post-colonial politics in Ghana. This statement was made by the Asantehene Otumfuo Osei Akoto II in his tribute to Baffour on his passing in 2002. Ladies and gentlemen, let me mention that we are live on Wontumi TV and Wontumi Radio, as well as City TV and Joy News. Now, anytime soon, we shall be watching a documentary on the life of Baffour Osei Akoto, and then we shall have a drama by the students of the Ghana School of Law on the trial of Baffour Osei Akoto. Ladies and gentlemen, the special guest of honor is the Minister of the Gospel, former Member of Parliament. He has been a High Commissioner and a former and immediate past Speaker of the Parliament of the Republic of Ghana. Right Honorable Reverend Professor Aaron Mike Okwe. Shall we receive the special guest of honor, Professor Mike Okwe?
Distinguished Chairman, Representative of the CJ, the Honorable Leonard Attorney General, the Honorable Dr. Efrie, Director of the Ghana School of Law, representative of the Asantehene Otumfuo, Dean UST and other faculty, lecturers and students, former President of the Ghana Bar, Chief Justice, clergy, distinguished ladies and gentlemen, students of law. it's a great pleasure to be part of this occasion. My paper will be on APPI Africa, that is the Africa Public Policy Institute. A for apple, P for pear, P for pear, I for ink. APPI Africa at yahoo.com, especially for the benefit of the young ones, the students, etc. And I know I have 10 minutes, but the program available to all of us, and I intend to go by it. For the sake of those who are not technical in their orientation, the Preventive Detention Act, PDA, 1958, and the date is important because sometime later some people will use this 1958 Act as a result of bomb throwing and other things which occurred even at about 1964. And you wonder, when people talk about bomb throwers, the bomb throwing allegedly at Kulungugu was the cause of the PDA in 1958. The chronology of events should give you room for thought. And it simply was a mechanism applied by Dr. Nkrumah and his regime to detain any Ghanaians for 5 years. Later it was amended, renewable for further 5 years. Anytime the government was persuaded that a person was acting in a manner prejudicial to the security of the state. What constituted prejudicial was the bona fide interpretation of the president alone. It was under this act that Baffour Osei Akoto, chief linguist, and others were detained. Dr. J.B. Dankwa applied to the High Court for release of the detainees under the Habeas Corpus Act, that is, bring the body. This was promptly denied by the High Court. Dr. Dankwa then proceeded to the Supreme Court to test and challenge the constitutionality of the PDA itself. He argued, among other things, that the Supreme Court was bound to inquire into the veracity of the alleged grounds in the detention order by virtue of the Habeas Corpus Act 1816. Second, the grounds upon which the appellants were detained fell outside the ambit of the expression acts prejudicial to the security of the state. Third, the PDA was in excess of the powers conferred on Parliament by the Constitution. To Dankwa, the solemn declaration of the President on the occasion of his being sworn into office that he will do justice to all manner of men, etc., constituted a Bill of Rights, and he could not swear to do right and justice only to turn around and arbitrarily imprison people. This was the essence of it. Geoffrey Bing, the Attorney General, the Honorable Learned Attorney General, very competent also in his law, but looking at the matter only from the British perspective, which was of course manifestly wrong, said, as for that oath that the president took, it was only like the British monarch's coronation oath. It did not constitute a legal Bill of Rights. It was not justiciable That is, you could not take it to court. If you don't like what the president is doing, vote against him when you come to elections. That is the sanction available. Distinguished ladies and gentlemen, the court upheld the latter submission. And in a way, not too surprisingly, because we had not gone the American way of providing for fundamental human rights. We were leaning at that time on the British model. And as for British model, it is only actually fit for only British, because they have no written constitution even. They don't need it. They have a society that does not need that. So it was, if I may now jump, that when the occasion came in 1966 for us now to do away with the Nkrumah regime and have a new order, in 1969, the Constitutional Committee, headed by lawyer Akufo-Addo, father of the current president, ensured that our constitution was an instrument of legal liberty, and that our human rights were justiciable. Very, very important for posterity. Distinguished ladies and gentlemen, the aims of the objectives of the NLM, which have been well listed in the paper, which you will have online, etc., and by hard copy when this has ended, list out clearly that it was not for the sake of bomb throwing and other activities, but to protect, among other things, human rights, separation of powers, and the fact that in this nation we hold to the view that onipa nye abua. This is very fundamental. And in fact, this is the essence of what the whole struggle was about. It was a struggle against corruption, because in the paper you read, among other things, how the cocoa purchasing company had been formed as an instrument of corruption. And of course, the cocoa people in Ashanti and elsewhere, Ashanti, which then included Brong-Ahafo, were not just going to sit there. It was not a bomb throwing exercise. It was a genuine protest to ensure human rights, including economic liberty. The cocoa people in Ashanti and elsewhere, Ashanti, which then included Brong-Ahafo, were not just going to sit there. It was not a bomb throwing exercise. It was a genuine protest to ensure human rights, including economic liberty. Are limited, and the constitutionality of any act of the Parliament of Ghana may be challenged in the Supreme Court, and to the extent of its unconstitutionality, it may be shut down as illegal. Regarding this, we have Ray Akoto. You cannot detain a Ghanaian beyond 48 hours and just keep him there. It cannot happen. By the Article 55 of the 1960 Constitution, the President could declare a state of emergency and rule by presidential fiat. You cannot do that today. Where did it come on from? It is also from the developments in Ray Akoto. Multi-party democracy is now enshrined in the Constitution. Nobody can declare one-party state in Ghana. Why? because of the developments emanating from Ray Akoto. When you think of the independence of the judiciary and the capacity of the president of the First Republic to declare a verdict of the court, the Supreme Court, null and void, and knowing that you cannot do that today, and all Ghanaians are satisfied with the fact that you just can't, remember Ray Akoto. Limitation of tenure of the president. You cannot just rule beyond 8 years, and all these are part of the after effects of what we are talking about. Socialism and all those things are gone. We now have all these as part of the process. Finally, to the lawyers, I will say the young ones who are coming. This case was done by Dr. Dankwa as a matter of principle, and he followed it to the letter. Lawyers, you are protectors of human rights. You are protectors of the liberty of the citizen, and you must rise and shine whenever there's a challenge that will undermine the liberty of any Ghanaian in any manner whatsoever. I thank you very much for your attention.
Immediate past Speaker of Parliament of the Republic of Ghana, Right Honorable Professor Aaron Mike Okwe. A cultural icon and politician, born on the 22nd February 1904, best described as a true royal and a possessor of two lights, in the essence that both of his parents were of royal descent. His father, Nana Uzusechre, chief of Ankasi in the Kwabri district near Kumasi, was the grandson of Asantehene Osei Akoto, 1800 to 1824. His mother, Obapeni Akosua of Kwabri Heman, was also the great-granddaughter of Asantehene Osei Akoto. He took on the noble title Baffour when he ascended to the Butuakwa and Apiachami stool in 1935. Ladies and gentlemen, please sit relaxed and watch a documentary on the life of the man, Ochame Baffour Osei Akoto.
As part of his daily routine, has grabbed a copy of the daily newspaper and was listening to his favorite talk show on Focus 94.3 FM.
Good afternoon to every one of you. A very good afternoon to every one of you, and welcome to Focus 94.3 FM. My name is Monique Ohnewan Kroma. So today we've got something interesting for you. We have a good news to share with you. It's about the biggest program about to happen tomorrow at the Great Hall of Kwame Nkrumah University of Science and Technology. Today I have with me lawyer and my learned and abled men in the studio, man and a woman here in the studio to talk about the program. So let's get right into it. We have lawyer Yam Mansa, who is a lawyer by name, and also we have Kweku Bibini Broni, a senior political analyst. So let's get right into it. So they are here to tell us all we need to know about the Preventive Detention Act, which was passed by Parliament under the Kwame Nkrumah regime. So welcome, good to have you on the show today. Okay, so let me turn right to lawyer. Lawyer, talk to us about what this PDA, a lot of people are happy with it, and people are also, of course, you know, not happy with the PDA. So tell us what the PDA is about.
A very good afternoon to you and your listeners. Okay. The Preventive Detention Act was passed yesterday by Parliament to be part of the laws of our country. The Act empowers the Prime Minister to arrest and detain without trial people whose acts were considered prejudicial to the state.
Wow.
I look at Section 2 provides that the Preventive Detention Act states, I would like to read for the benefit of your listeners.
Sure.
The President may order the detention of any person who is a citizen of Ghana if satisfied that the order is necessary to prevent that person from acting in a manner prejudicial to A, the defense of Ghana, B, the relations of Ghana with other countries, or C, the security of the state. What this means is that the President places the interest of the nation first, and he will ensure that this interest is protected at all times.
Hold, lawyer. Please be honest. We both know that the law that has been enacted by Parliament is incurably bad and will definitely end up as an instrument for political persecution.
Okay, so over to lawyer. So are you against this PDA or you are for it?
I am definitely for this PDA.
Okay.
We both know that this Preventive Detention Act is here to serve the best interest of all Ghanaian citizens. That's exactly why this PDA was passed. Now, if my good friend here is going to keep cutting me, then why don't I leave the show so he can go ahead and bring up any propaganda he wishes to speak on?
I believe that your learned friend will take a cue from that too.
Well, there is definitely no agenda here. You can definitely understand from what she read that the act gives the president a wide discretion in terms of what he can do. I mean, he can just arrest anyone he wants in pursuance of defense of the nation. Okay. There is no agenda. There is definitely no propaganda. We just want to ensure that the law that is made is good for the interest of the people of Ghana. That is all.
Okay. So thank you very much. I believe that people listening appreciate what this Preventive Detention Act is all about. So thank you very much for tuning in today for this program. And I believe that you appreciate the Preventive Detention Act passed by Kwame Nkrumah some years ago. And if you want to get, an expanded knowledge on this, please make sure you are there to learn from these experienced people. But before I end the program, we'll be talking to Mr. Nene in a bit about the program tomorrow. So stay tuned, we'll be right back.
Hey, Nkrumah, Kwame Nkrumah, is this what he meant when he said on Independence Eve that Ghana is free forever? What did he want to say when he said that the black man is capable of managing his own affairs? Did he mean he wanted to become a dictator and a tyrant? To pass a PDA that will seek to infringe on the rights of individuals of this nation? He does not know who I am. I am Baffour Osei Akoto. Asanteman yina chia me penny. Me, himai this year papa bi. I will show him that I am a true statesman and a patriot. I shall fight and test the constitutionality of this PDA. And then the kind of time I'm anate. Baffour Osei Akoto, makaseri.
Approximately a year later, on the 10th and 11th of October, 1959, Baffour Osei Akoto, a senior linguist of the Asante-Hene, was arrested under this PDA issued by the Governor General and signed by the Minister of Interior under Section 2 of the Act. He was arrested together with 7 others, namely Peter Alex Danso, alias Kweku Danso, Osei Esibi Mensah, Nana Entry Bosiakon, alias John Mensah, Joseph Kojo Entry Kusi, alias Anani Entry Kusi, Benjamin Kweku Owusu, Andrew Kojo Edosei, and Halidu Kremu. The grounds for the detention were that they encouraged the commission of acts of violence in the Ashanti and Brong-Ahafo regions and associated themselves with persons who have adopted a policy of violence as means of achieving political aims in those regions. Baffour Akoto was a founding member of the National Liberation Movement, NLM, a political setup that advocated for a federated Ghana.
So this is actually true, that a Preventive Detention Act has been passed by the Governor General? Nkrumah, we shall see. But like I said, I am a true statesman, and I shall indeed test the constitutionality of this PDA. Nkrumah, obechi amamayam.
Court rise.
We make these arguments in support of the instant appeal and pray this honorable court to overturn the High Court's decision and allow the appellant to be brought before this honorable court for trial. Respectfully submitted, Dr. Boachi Dankwa.
Very well. Thank you. Order. Order. So, J.B. Dankwa, it is your case that the PDA is unconstitutional and this Supreme Court should strike it out?
That is so, my lord.
Okay. Please, the respondent, can we please hear you? And briefly, please.
May it please this honorable court, I would briefly respond to the arguments that has been made by J.B. Dankwa. In response to his first submission, we submit that under Rule 14 of Order 59, the High Court judge was not mandated to make an order of formal return before making the determination. He could have relied solely on the affidavit evidence, and this he did. In response to his second submission, which is that by virtue of Section 3 of the Habeas Corpus Act, the court was bound to inquire into the truth of the facts that were alleged, we submit that although admittedly the Habeas Corpus Act in itself is a statute of general application, it does not apply to the Preventive Detention Act under which the appellants were detained, because this vests into the Governor General the power to arrest without trial. In response to his third submission, we submit that where he impugns the good faith of a public officer, pursuant to the presumption of regularity of performance of duties, he must lead positive evidence to establish that the public officer acted in bad faith. He has not led any such submission. We submit that where he impugns the good faith of a public officer, pursuant to the presumption of regularity of performance of duties, he must lead positive evidence to establish that the public officer acted in bad faith. He has not led any such evidence, and accordingly, this contention must not hold. In response to his fourth submission, we submit that the statement security of the state is not limited only to the defense of Ghana against foreign powers. The PDA may be invoked in law where the basis of the law or the basis of the action is sought to undermine the essential security of the state. And this is what the alleged individuals did. And accordingly, the PDA was rightfully invoked. In response to his fifth submission, we submit that the PDA was passed by the power of Parliament given under the Act. Accordingly, the Governor General is not precluded from exercising these powers pursuant to the principle of parliamentary sovereignty. And finally, we submit that Parliament is competent to pass the Preventive Detention Act not only in war times, but during times of peace, and therefore the court threw out the application that counsel made. Respectfully submitted, Geoffrey Bing.
Thank you. Thank you so much. All right. So, both counsels, thank you so much for your submissions. And this application is dismissed. We shall return with our reasons thereafter. Thank you.
At the end of the trial, the Supreme Court ruled that the PDA was law rightly passed by Parliament and therefore part of the laws of the country. The Prime Minister, Dr. Kwame Nkrumah, under the powers given him under the PDA, continued to arrest and detain without trial certain individuals in the country, arguably on grounds of political expediency. This case, Akoto and 7 others, will go on to be celebrated as a landmark case in our constitutional dispensation, with some scholars arguing that it was constitutionality as against constitutionalism. Additionally, all other constitutions after the 1960 Constitution went on to provide expressly for a binding Bill of Rights in answer to the interpretation given by the court to Article 13 of the 1960 Constitution. This case, in conclusion, shaped the constitutional and judicial history of Ghana. And this, dear ladies and gentlemen, was the story of the arrest and detention of Baffour Osei Akoto and 7 others. Thank you very much for indulging. I have been your narrator, Kezia Angel Clottey. The end.
Thank you so very much, students of the Ghana School of Law. Mr. Chairman, distinguished ladies and gentlemen, we're still celebrating the man Baffour Osei Akoto, the man who holds the unique and enviable record of being the first Ochame in the history to have successfully served 3 Asante kings. He served under the Baffour Osei Akoto II from 1935 to 1970. The Baffour Pokuare II from 1970 to 1999. And the current occupant of the Golden Stool, Baffour Osei Akoto II from 1999 to present. Now, Baffour's ascension to the Butuakwa and Apia Chiami stool began what has today become a memorable and timeless legacy, a legacy that will be celebrated for many, many years to come. Ladies and gentlemen, I now invite Mr. Abokuma Emisakumson, he is the acting SRC president, to introduce to us Miss Abokuma Emisakumson, acting SRC president, to introduce to us the speaker for the day. Now, after the introduction, the speaker will be ushered onto the podium by Engineer Opoku Fontom from Edupoku Fontom from Atapoku Fontom from. So let's have you, Miss Emisakumson.
Mr. Chairman, please permit me to stand on all the protocols observed to introduce to you our speaker for our memorial lecture. Our speaker holds MSc and PhD degrees in agricultural economics from the University of Cambridge, England. He worked as an economist, senior economist, principal economist, and chief economic advisor over a period of 18 years at the International Coffee Organization, London. He has also worked as a consultant to the World Bank and the United Nations on soft commodities, cocoa, coffee, sugar. Between 1995 and 2007, he was the CEO of 2 international commodity companies, Goldcrest Commodities Limited and Plantation Resources Limited, both based in Ghana. In 2008, he was elected to the Parliament of the Republic of Ghana. He spent 2 terms as Member of Parliament for Kwadaso constituency in Kumasi, Ashanti region. In Parliament, he held the positions of Deputy Ranking Member and subsequently the substantive ranking member for the Committee on Food Agriculture, and Cocoa Affairs until 2017. In 2017, he was appointed the Minister for Food and Agriculture. In this role, he has spearheaded the design and implementation of the government of Ghana's popular and transformational agricultural flagship program, Planting for Food and Jobs. Under his leadership, Ghana has been transformed into the breadbasket of West Africa, moving from not being on track in 2017 to being on track in 2019 on the African Agriculture Transformation Scorecard. In that same year, 2019, Ghana was ranked 4th on the African continent by the Economic Intelligence Unit in its Global Food Security Index. In February 2019, Africa Seeds, which is the intergovernmental seed agency of the African Union, conferred on him the title of Seed Champion of Africa. Later the same year, he was appointed chairman of the board of the Inter-African Coffee Organization, a Pan-African organization promoting the interests of coffee producers on the continent, a term he finished serving in December 2020. He is the current chairman of the ECOWAS Specialized Ministerial Technical Council for Agriculture, and he is a son of Ochiame Baffour Osei Akoto. Ladies and gentlemen, I introduce to you our speaker for today, the Minister for Food and Agriculture, Dr. Owusu Efiye Akoto.
Thank you very much. Thank you very much. The chairman of today's auspicious event, Venerable Mr. Kwame Pianim, the representative of Otumfuo Osei Abebio, Nana Anantahene, representative of His Lordship, the Chief Justice, Dennis Ajay, the former Speaker of Parliament, the Right Honorable Professor Michael Aaron Okwe, the Attorney General and Minister for Justice, Honorable Godfred Dami, members of Parliament, the Acting Director of the Ghana School of Law and Faculty, here present, the representatives of the Vice Chancellor